Chief Justice Morrison R. Waite argued that every government had the power to decide whether patriarchal marriage or monogamy, which of the two or both, should or should not be the law of the land, the basis of social life. Obviously, Congress assumed that they had this power when they passed the law, as did President Lincoln when he signed the law. Yet, we ask, where in the Constitution does the national government, or where was the national government given the power to determine if a society will be monogamous or plural? Where in the Constitution did our founding fathers grant the federal government or the states the right to determine what kind of a social life will be conducted in the United States? Monogamous, plural, or both? Where in the Constitution were those rights granted to either federal or state authorities? Of course, the answer is nowhere. In reading the Constitution carefully, you will find that there is no such delegated power to either the federal or state government. We do, however, find two amendments that forbid this kind of family decision-making process to the government, federal and state. I'll say that again. We do find not one, but two amendments of the United States Constitution that forbid the government from deciding what kind of lifestyle is and is not acceptable in these United States. The Supreme Court is considered the court of our last resort, protecting individual rights of citizens against the unjust power of government. We have here, however, an instance where the court openly, in 1879, Reynolds versus USA, in 1879, where the courts openly usurped the power never given by the consent of we the people, given that power to the federal and state governments, never sanctioned by we the people, to dictate and enforce what is normal, socially normal and acceptable, and what is not socially normal and acceptable among the citizens, thus removing our freedom, the freedom of the citizens, we the people, to determine what is and what is not the lifestyle that we choose, where it is up now it is up, according to these unconstitutional rulings and by the Supreme Court signed by President Lincoln. It is now up to the federal and state government to determine what is normally acceptable in society and what kind of relationships and marriages are acceptable in society. The Morrill Anti-Bigamy Act of 1862 was not a law, but itself a violation of the law. So in other words, this act, the Morrill Anti-Bigamy Act of 1862, was challenged in 1879 in Reynolds versus the U.S., which upheld the legitimacy of this law. The problem was the Morrill Anti-Bigamy Act of 1862 was not a law, but the act itself was a violation of the Constitution. So then they increased the problem by pronouncing that the violation of the Constitution, or the act, the Morrill Anti-Bigamy Act of 1862, they upheld its legitimacy in Reynolds versus USA 1879. Problem was, the act is illegal, so they illegally upheld an illegality. They compounded it, see? These are the facts. Don't make up your own facts. You're not entitled to your own facts. You are entitled to your own opinion, but you're not entitled to your own facts. Praise the name of Yahuwah. Praise the name of Yahuwah. Let his truth set all the people free. You can't expose man's nefarious deeds and activities and clandestine workings and seductions of Satan through unregenerate man until you address what man does and man's opinions. And that's why we're taking this from a legal perspective and not only from a scriptural perspective. In addition to usurping power to establish social normalities in society, to decide whether plural marriage or monogamy should be the basis of social life, in passing and then upholding the Morrill Anti-Bigamy Act, Congress assumed a new power, or another power, without the consent of the governed, we the people, it assumed and assigned to itself a power to selectively breed the American citizenry. Say it again. To selectively breed the American citizenry. So they took a power not granted to it in the Constitution to decide what is and what is not socially normal, as opposed to the family, the kingdom unit, the individual nuclear unit deciding what is and what is not in its best interest, took that power that was never given to the federal government or the state, usurped that power, and declared anyone who disagrees with them to be in violation of the so-called laws of the land. Are you still with me? I'm going to need another cup of coffee just to keep up with you, to make sure that you're still with me. Pardon me while I sip. Got to keep that whistle wet, you know what I'm saying? Now listen, can a government interfere in the United States? We're not talking about in some third world countries. I can care less. Okay, most of those are banana republics anyway. Can a government interfere with an individual's rights or choice of a spouse or spouses without assuming the power of selective breeding that exists only in absolute fascism and despotism, like in the days of Hitler, because he tried to control breeding, European breeding, through a pure Aryan race by getting rid of all the gypsies and the Jews and anybody else he determines was not pure for breeding. And that's exactly what these government laws are designed to do. To get rid of the undesirables, and the undesirables is anyone who disagrees or disapproves of the social norms of the land, called the so-called law of the land, that the government granted itself a power that the Constitution forbids. The Constitution says in the 10th Amendment that if the power is not given by the deeding of the Constitution to the federal or state government, the rights belong to the people. The Constitution makes no power to conduct social norms or marriages. Marriages is an area that is given over to the power of the people, because it makes no such claim that the power to determine what is and what is not a legal marriage to be made by the state or the federal government. Can you deny a black person the right to marry a white person without engaging in the power of selective breeding? You cannot deny a single woman the right to marry a married man without enforcing the same power, selective breeding. You cannot. If you deny a woman the right to choose a certain man as her husband, you have asserted the power to deny her her very constitutional freedom that you disapprove of, leaving her only your choice for a mate for her. Your power to deny her choice is the power of selective breeding, a power we rightly exercise over cattle and over dogs, but not over people. I'll say it again. When you deny an individual the power to select her breeding and her mate, a power, you deny the human being the power which we give over to our cattle and our dogs, who have the freedom to mate and to breed in the natural with those that they want to. Now, the Declaration of Independence asserts this truth to be self-evident, that we have the freedom to choose our mates and to choose the breeding and to choose the lifestyle. It is the power of the 10th Amendment given over to we the people. It is not a power delegated to the government. The Morrill Anti-Bigamy Act of 1862 was illegal, and the Reynolds versus USA was an illegality confirming the prior illegality, assuming a power that the federal and state government were forbidden to have in the United States. The Declaration of Independence asserts this truth to be self-evident, that to secure the rights, governments are instituted among men, deriving their just, listen carefully, deriving their just powers from the consent of the governed. It is the consent of the governed who give governments the power. And the consent of the governed of July 4th, 1776, gave the government no such power over the affairs of men when it comes to biblical marriage, biblical living,